Item number
49.
49.
49, Lordship.
A joint request matter stands
Ah,
referred
yes.
to be listed after 3 weeks,
Lordship, last week of January.
4
Since
weeks, 6 weeks. All right.
Lord.
Item 40,
9.
joint request. Matter stands referred listed after 6 weeks.
Keep your
Yes, yes, yes.
May I please, your Lordship, regarding item number 40, your Lordship, as the opposite party is yet to file their reply, some time may be given to them.
It's for them to ask. Why are you making a mention?
Lordship, I'm not well today.
You say that. You say you want an adjournment today on your ground. Take it.
Or maybe kept for
Let
2
the matter
p.m.
be called up.
Maybe kept for 2
Yes,
p.m. your
yes,
Lordship.
yes, yes.
May it please your
On which time?
Lordship, with consent of the other side, I'd like to mention
Please,
item number 32. Your
30?
32. Your Lordship, I am appearing for respondent number 427. Your Lordship, instructions are still awaited in this matter.
Have you taken consent to the
Yes, I have taken.
I am.
No objection? Item 32 to be listed after
3
3
weeks,
weeks.
My lord,
At the request of counsel for the
Access.
Axis Bank.
Respondent number 427.
427. Yes.
may please, I beg to
Public.
mention item number 30,
30.
30. With the consent of other parties, 4 weeks time may be granted for filing.
You are for the
I am for the respondent 7.
who's for the petitioner? Have you taken consent?
Yesterday I have taken.
Item 30 is the request of Mr.
A Kapra.
A. Kapra, learned counsel.
My name is not shown in the call.
Name of all counsel.
May please, your Lordship. With the consent of other parties, I beg to mention item number 45. I am on behalf of Mr. P. Sir, arguing counsel for the petitioner. The matter will be adjourned for the day because he is out of station.
Item 45.
May please,
Leave
Lordship,
the
the item number 58, Lordship, supplementary. Lordship, the overall the matter, Lordship, with liberty, Lordship, there's some defect, Lordship.
Item 58. The
58,
request of learned counsel.
with liberty.
Dismissed on withdrawal in reported in the Liberty.
Yeah, please, Your Lordship. I beg to mention item 35. We were supposed to file our affidavit, but the client is not well, so she could not come.
You're for the respondent.
Respondent 1, Lordship. 2 weeks time be
Have
given.
you taken consent of the
Yes,
counsel
Lordship,
for
we have taken the
petitioner?
consent.
Item 35 is the request of counsel. Consent matter is referred to the
Obliged, Lordship.
May please, your Lordship. Lordship, with the consent from other side, I beg to mention item number 44, Lordship. Maybe it may be adjourned for the day.
I am for the respondent
13.
because of engaged counsel.
Item number
44.
44 be listed on
13.
What?
Item
all right 30.
May please, Your Lordship. Lordship, I beg to mention item number 37. My Lord, conducting counsel Mr. P. Patel is having some medical issues, so item may be adjourned for today.
Have you informed the petitioner?
Yes, my Lord.
Your name?
M. Sharma.
The name submit the consent of the counsel. That the counsel represents on the report. Submit the matter. Where allowed is after 1 week.
May it please, Your Lordship. Lordship, I beg to mention item number 50, Lordship. Lordship, we are supposed to file a affidavit regarding the photograph, and we will file today. Kindly adjourn the matter for today.
Have you informed petitioner?
We are the petitioner
You are the petitioner. You want to file what affidavit?
regarding the photograph.
Item 50.
Kindly fix it on 29 November.
Item 50. Yes. 29. Yes, as per the request in the account. Submitted consent of the court. Yes.
May I please, Lordship?
My lord, I beg to mention for leaving two more, my lord, certain matter, my lord, eviction matter.
Tomorrow, no. Wednesday.
My lord, there is absence, my lord.
Wednesday.
Please mention item number 25 and 26, my lord. Small accommodation required, my lord, today. Any date next week or next week.
25.
And 26, my lord.
Request of
Corrected, ma'am.
council for the matter matters and referred to the minister after 1 week.
Date may
Will come as per convenience.
Lordship, I am praying for an adjournment for item number 4 on behalf of the.
Item 4. Why? Complied.
Budget has been released, Lordship.
Then you point it out when the matter is pulled up. You wait for the matter to be pulled up.
Sir, senior is currently out of state.
You are there, you remain.
May I please, Your Lordship, I beg to mention for listing for the author, is an additional demand of interest and non-due issuance of additional demand of
Where?
interest and non-issuance of notice.
Yes. It is it.
better part is non-refund of GST matter. Occasion question was confirmed.
Petitioner was asked to file an additional affidavit.
But
Lordship, may I kindly see one notification of 25/1/2023 here, Lordship. Hereby the GST in respect of the work which completed on or after 18/7/2022 was enhanced to 18%. So that notification, if that notification stands, Lordship, petitioner has to be,
Where is that notification?
Lordship, may I kindly see at page, annexure C, page 16.
And what is the case of the petition?
My lord, the petitioner had completed the work, my lord, before, my lord, 18 July 2022. That is the case. After 18 July 22, my lord, it will be 18%. Before that, my lord, it should be 12%.
This bill was submitted in the January 2023.
Yes.
And for that reason only, Lordship, a direction was issued for filing an additional.
No, that,
Have you filed your affidavit?
that is pertinent, whether the work was completed or not, my lord. But I will file, my lord, I have already written to the company, my lord, of the company, my lord. Now, my lord, page 23, my lord, your lordship has to look at. Page 23, my lord, here, my lord, the bill submitted after, my lord, 1/4/23, my lord, that will be 18%. Yes, 18.
You first file the affidavit. There is direction
My lord, my lord, I will file.
directed to file an affidavit with furnish further detail.
Details,
Fine.
my lord, yes.
Mr. S. Hope, let us come. Praise for further time. Earlier order independent. P. Naik. PWD.
All the three.
After.
Oblige.
Budget has been, budget has been released, Lordship. The intimation letter to the district commissioner. Okay.
Has it been disbursed?
Lordship, the district commissioner is the disbursing authority, Lordship.
Find out and tell us whether it has been disbursed.
Now, Lordship, this was the direction to the district commissioner to disburse the
Madam, you are in contempt in response to an order already passed. You are inviting another direction. You find out and tell us whether the DC has released it or
Now,
not.
Lordship, may peruse the page number 20, Lordship. This is a letter from district commissioner West Kabyang, Lord.
You see the last part of the order. You are directed to take steps so that the balance amount is paid. Now you are sanctioning this amount and transferring it to the DC.
Sure.
But the
Lordship,
DC,
DC is the disbursing authority.
who is appearing for the DC?
Lordship, notice was not issued, Lordship. This case,
Please find out whether this amount, do you have an extra copy? You
Sure.
share it with him. Whether the amount has been disbursed to the petitioner. Right? Based on Friday, you give him a copy.
Lordship, may keep this intimation letter as a part of that one.
Yes, we are keeping it. MS
You are
so that council appearing for the revenue submits that the amount directed to sanction in terms of the order dated when passed in the sanction. So, the council appearing representing the DC will obtain instructions whether the amount is ready. It's again on 29.
May I please? Is it contempt petition, my lord?
Which
With
order?
Violation of order. That is
Which order?
18
Which order? Page number
Page number 14, my lord.
14.
Start from 14. My lord. Particular, page 18, para 8, my lord.
What violation has happened? This is an interim order.
My lord. Construction is going on, my lord.
You file an application for enforcement of this order.
We
Have
have,
you brought it to the notice of the
we
court?
have communicated this order, my lord.
Third learned counsel for the party submitted that contempt petition has been filed for not compliance with the order dated 18/12/2023 passed in W69. So perusal of the order dated 18/12/2023 repeat that the direction the direction was issued to the respondents 3 and 4 that there shall be no further construction in respect of 4th and 5th floor of the building in question till the next return. So it's submitted that the writ petition according to this contempt petition be listed along with WPC. Let both matters be listed together.
That not fixed. That was not fixed. That not fixed, my lord.
Registry will fix and list it.
How much?
Maybe. My lord, the order at Lordship would find at page number 9, my lord. That order has not been complied. The matter pertains to the release of ex gratia amount.
Okay. Third learned counsel for party agreed by the order dated 2025. Agreed by not comply. Will be deliberate not comply. Step of responsibility. Sole responsibility by
Obliged.
This second bail application. SPL.
call for CD.
Sure.
Coming from Kokrajhar.
Yes.
It's not.
Lordship, 4th of December.
4th of December.
Nice. Since June, my lords, there's no progress in the investigation matter. Lastly, the matter will state 20th of June matter.
Yes. What progress?
My lord, in fact, police has taken all appropriate steps measures to investigate the matter. Accordingly, my lord, on June 19/7/2024, the status report.
Can you bring it on record by an affidavit?
What if now refer, my lord, we can fight it.
Heard that counsel for the court, Mr. P. Gupta, that investigate the progress in the matter. It received instruction from the department that the status or progress in investigation aspect of office of the place before the court by the it's after the
Lords may have it on 16th of December. One more matter is listed on that date. I have to fly down to Guwahati from Delhi.
you don't have to. We have BC facility if you want.
Actually, I have to come in an arbitration.
You are willing to come, you're most welcome.
Is my
But don't say you have to.
my lords, one
It's
more
an option
submission,
here.
my lords. I may I have one more submission, my lord. Accused is partner, my lords, in the firm. He is my partner.
Sorry.
He is my partner. Accused in the partnership firm. We have proprietary interest, my lords. I have no issues if he takes legal recourse, my lord. I have initiated legal recourse against him for civil rights. But he takes extra legal things, my lord. He has a licensed firearm, my lord.
Let us find out what is the step. If you have any threat perception, you are there to can approach the local police station.
My actually he has a firearm license, man, of the state given, my lord.
So that's
My threat
permissible.
perception is genuine, my lords. I have joined my business in Guwahati after this case, my lord. So he has not appeared in the case as yet, my lord. The private respondent.
So what do you want from the court?
But some sort of protection should be
So that protection the court can give you. You have to approach the concerned law enforcement authority.
my lord. I'll be filing affidavit in this regard.
File it whatever you want to file, but first you must approach the law enforcement authority. It's on 16.
After 3 weeks,
16. 16 December?
16 December. Please.
Matter earlier came up before your this honorable court on 23/9/2024, and this honorable court directed to ask some documents for which I have filed additional affidavit that your lordship will find at page 73.
So first tell us what is your case.
Dear lordship, the respondent authorities have acquired our land, but they have not paid the compensation amount. And when the matter was heard on the first day, the court put a query that whether you were having those lands prior to acquisition or not. Because the respondent said that initially those were government lands, and subsequently we have applied for the compensation. And in terms of that order, I have filed additional affidavit which shows that prior to initiating the acquisition process, I was holding those lands. I was in possession of those lands. So at this stage, lordship, notice may go and let them file the affidavit.
Heard Mr. A. Mr. S. Mary appearing court.
Two, my lord. I for 1 7 minutes. And I am for 2 to 6.
Respondent. Right. Any additional city?
Senior road.
Airport.
1, 7 and 8.
1,
7 and 8.
1, 7. Notice that. Period of 1 week. Right.
Okay.
Yeah, my lord, also regarding my lord compensation for acquisition of land, my lord. Last occasion, at the Honorable Court asked a report to submit to the government regarding speaking order passed by the Deputy Commissioner.
Yes, Mr. Borua, who's there?
I received the speaking order.
You have. What have you decided?
Vernacular logic.
Tell us. What is that? 6 crore. What is the amount? Six lakh.
Yes, my lord. 6 lakhs.
So there is an order of payment in your paper.
Already lordship will
Promila
find,
Das.
yeah, lordship will find page, page 25. Page 25 is the type copy, my lord. Notice has been given to me to receive the amount and file. And vernacular page 27.
Yes.
Golok Das is my father, man, who expired in the meantime.
Who is Promila?
Pramila is the wife of Golok Das, but she is for long 20-25 years, she is living separate.
Mother logic. It is the
Mother of the petitioner.
Mother of the, so the fight is between mother and son.
son. Yes.
Then she's the wife. Amount has been given to your mother. Why do you want to take it from her?
Because, my lord, I have also a shop, man. There was a shop of my father. I was also running the shop, man. The compensation of the shop at least is to be given to me, madam. He is not providing anything, my lord. So I have incurred heavy loss. In that regard, my lord, I have some claim.
This order is there. You want to go, have you got a copy of this order?
No, no, no.
You go through this order. It has already been decided. You have remedies under the law in respect of this order. We'll take it up after a while, go through the order.
Next is your lordship. So I am challenging the order, my lord, to take 43, my lord, on the point of jurisdiction, my lord. Locus was issued under section 74 of the CGST Act, my lord. Number section 74, my lord, requires certain requirement, my lord. Ingredients that is not
No
there. my
appeal,
lord.
no appeal.
Appeal lies, I am on the point of jurisdiction, my lord, only, my lord, because
Uh.
section 74 says there has to suppression of facts, my lord. There is no allegation because the petitioner's file is returned, my lord.
Go and appeal, you can urge all this before the appellate authority. Why do you want to trouble the court to find out whether there was suppression or no suppression?
On admitted facts, I am arguing, my lord, I'm not going on the merits of the case, my lord. If lordship permits, or I can also go for appeal, my lordship is definitely.
You don't want to pay the statutory dues. That's why.
No, my, but on the face of the document, my lord, it can be seen that there was no suppression, my lord. And there is no finding of suppression of facts also, my lord, in the order, my lord.
Where is that order?
Order starts from page 43, my lord, and operated. Finding your lordship will find it page 56, my lord. Last paragraph, paragraph 4.6, my lord. I'm relying upon a circular, my lord. At page 61, my lord. And my last page 62, paragraph 3.3. When section 74 can be invoked, it is there, my lord. Department circular, my lord. Last paragraph 3.3, my lord.
Yeah.
May I read, my lord? From perusal of the wording of section 74(1) of the CGST Act, it is evident that section 74(1) can be invoked only in cases where there is a fraud or willful misstatement or suppression of facts to evade tax on the part of the said taxpayer. Section 74(1) cannot be invoked merely on account of non-payment of GST without specific element of fraud or willful misstatement or suppression of fact to evade tax. Therefore, only in the cases where the investigation indicates that there is material evidence of fraud or willful misstatement or suppression of fact to evade tax on the part of taxpayer, provisions of section 74(1) of CGST Act may be invoked for issuance of show cause notice, and such evidence should also made part of the show cause notice. Now, there is no investigation in the show cause notice reflect that there was a fraud, willful misstatement.
Why don't you go in appeal? Because it requires the fact finding. You see, you may be correct to say that there is no specific finding of suppression. But from the materials which were examined, which were placed, which you have relied on, one has to take a call whether there was at all any suppression.
But in light of the circular, my lord, they have to follow the circular.
No, they are to follow the circular, but the circular says the
where
there must be
investigation.
fraud and willful misstatement.
Yes, my lord. And in last line it says, my lord, such evidence should also be part of the show cause notice. Now, my lord, in the
What do you say, Mr.
It is there, Lordship, page 25, paragraph 6. Lordship, furthermore, this circular is not applicable in case of petition. That was issued with
Where is the show cause?
It is page start from
page 23, my lord.
First we come to paragraph 7, page 25.
Yes.
Marriage. Whereas it appears that excise ITC claim is indicated in table 1 above would have gone unnoticed, and it has not been for the reconciliation done by the department. It is the statutory obligation on the part of the SCC to correctly pay the statutory tax, file true and correct return. In the era of self-assessment, trust is placed on the SCC to correctly self-assess
It
their
says
tax liability.
tantamount to suppression.
Yes.
No, my lord, I'm coming, my lord. What is separate?
However, it's the case on the basis of the information received. It was noticed that the said SPI has deliberately taken and utilized excess ITC for discharging their tax liability. Therefore, it appears that the above submission by the SEC tax amount
There is
to
a reference.
suppression of tax.
I'm coming, my lord. What is suppression is explained in section 74, my lord.
Okay, furthermore, section 107, and Lordship, they have approached this honorable court after expiry of the limitation.
No, my
All right,
not,
heard,
it is
heard.
not expired, my lord. It is within limit,
General Counsel for the party.
my lord.
Mr. Kya, the case for the court. Court, you are challenging the show cause also.
No,
Only the order.
It is merged with the Socos, my lord.
The order, issued order dated
My lord, it is, my lord, 12/6/24, my lord.
12/6/2024, issued by the
Respondent number 4, my lord.
respondent number 4. Confirming a demand of
13,15,331, page 57, my lord.
13,60,031, including interest and late fee. Late fees and interest is above, over and above 13 lakh.
Yes, sir.
My lord.
13 lakh, 16,331. As well as late fee and demand for interest. Counsel for the jurisdiction of the assessing authority in passing the order was exercised under section 4. Referring to state that jurisdiction is issued only when there is prima facie evidence that petitioner is guilty of suppression or making his statement. However, no such finding in the written plea. Therefore, the petitioner can and the demand. He has also referred to a circular dated 13 December 2023 issued by CBI submit that the board entrusted with policy making respect has clearly laid down the guide, clearly laid down the manner in the way the provisions of section 74 is to be exercised. So, according to the circular, there must be broad or frequent mistake or expression of facts made fact on the part of the taxpayer. So, mere non-payment of GST without expressing element of fraud, will statement or suppression of fact like, no, will not give jurisdiction, yes, will not permit the assessing officer to give the tax of it, there is no finding fraud will state or suppression of fact assessing officer wrongly the report what and during the tendency of the order. So that here the other strong the focus is pursuant to the practice finding by pursuant by pursuant to the materials available to the authority that they have arrived at a prima facie conclusion that the taxpayer has deliberately taken or utilized excess ITC for discharging their tax liability. and such acts slash actions tantamount suppression the effect and thereby power of permitting the order. Heard the ground of order the statutory under section
107.
107, which the petitioner has not made, and no reason therefore have been raised. Considering the substance made by of the rate, three weeks, the respondent will file their will complete their object instruction file affidavit, right? So question of maintainability of the rate needs to be decided before proceeding further in the matter. Meanwhile, the maintainability, no coercive action be initiated in respect of the demand rate instruction order taken. List on 16th December.
Briefly about my lord.
Oh, since Mr. Gyal has already entered appearances, notices are waived extra for him. But
Briefly.
so some order has been passed. What do you do?
Yes, my lord, but it is not clear that whether any no objection has been taken from the my lord. There is order was
Order has been passed. If you want to challenge it, you have to take necessary step.
Yes, Lord. So, my lord, you may be allowed to withdraw my lord liberty to take appropriate.
You have the order dated
The 31 12 22.
22. In view of an order dated
31 12 22.
31 12 2020 passed by the
Deputy Commissioner, District Commissioner Sunit
Deputy Commissioner Sunit, whereby compensation is awarded to the mother of the victim, and which order that is responded to the court. The current counsel submit that this order was not brought like with liberty help say court to advise according to it and this is not brought in order that it liberty granted.
Right.
Copy of the order dated 12 with the current counsel. Yes.
Right.
Yes.
Maybe Lordship, by exhibit annexure B, page 14, the petitioner has made complaint before the respondent number 3, Register of Cooperative Society, regarding the functioning of respondent number 4 society by the respondent number 5 and 6. And that complaint was rejected by annexure C, page 15,
yes,
by the respondent number 3. And
we
again,
issue notice at this stage. Yes, Lord.
Section number 2 and 3 alone.
2 and 3.
1 by director. And the third.
Lord.
1.
1. And steps of respondent 4, 5, 6 by usual court and registered court within 1 week with us. And to be taken after that today. With the respondent 1 week are represented by count. Respective count.
Right.
maybe people. My lord, I have examined the maintainability, my lord. regarding appeal, my lord. So, my lord, I may be allowed to withdraw, my lord, with liberty to file appeal, my
Mr. Murray Lanekamp. It's like you wrote the written, it's delivered.
My lord.
Prayer is not objected by the standing council. NCA. Voting. It stands for all interim orders and it has to be delivered.
My lord, I may just pray one thing, my lord, because there is a limitation period, my lord. Well, my lord.
So,
there is a limitation period. So, my lord, that observation may be given, my lord, so that it will help me, my lord.
What, what limitation?
There is a period for limitation. Within 90 days, I have to prepare an appeal. So, since the judgment is of to February 13.
Is there a provision for confirmation of delay?
No, my lord. But that the order or in the order itself, we have to file an appeal within 90 days.
So we can't give you an observation. What observation you want?
Otherwise, my lord, it will.
What observation you want?
That period, the period that I have spent, my lord.
Okay. This repetition is not pressed in view of appellate forum of the council for the subject. Repetition was by the wrong understanding of the view of the liberty to approach the statutory forum. Statutory forum. Appeal.
Before this court. Appeal lies before this court.
The appeal. Benefit, if any, respect to the granted if otherwise not.
I'm obliged, madam. Obliged.
Let it come on Wednesday. Wednesday.
Wednesday,
My lord, in this case, I don't think I can pray for any interim order. But only thing is, my lord, the issue has to be resolved. So let my lord counsel for the GMC take the instruction. Matter can come up on Friday, my lord.
Yes.
My lord, there is a dispute between landlord and tenant that is going on. Now, what the landlord has done, my lord, as you have seen, and structure has been just put up in front of my shop, my lord. GMC has, to our knowledge, has not given any permission.
You get.
I will definitely have that. Recently, what happened, Lord, in the same Udubari area, we removed one kiosk. And the plastic
Oh, that was that.
board directed me to put it there again, Lord. So
no,
I have to take instruction, but
Can you
complaint
get it?
is
Can you
already
get
there.
it by Friday?
Right, Lord.
Friday. I think the photographs reflects the actual state of affairs.
Considering the limited prayer, considering the prayer of the prisoner, that the landowner had put some obstruction in front of the shop of the petitioner, thereby preventing him to carry out business, and which obstruction was put by the landlord without any permission or sanction from the competent authority, namely the GMC. So let the standing council the matter be listed on Friday. Right. Invite the council on record or the standing council during the course of the day
Yeah.
to enable him to pay their fine.
Pendency shall not be a bar for them to take some.
No, let it be on
Kamal.
Friday. Right.
Deep breath.
May I please, my lord? My lord, here in this case, my lord, I am the chairman of a cooperative society, village level cooperative society, my lord. I was against me, my lord, no confidence motion was passed. I filed an objection before the assistant register of cooperative society. Assistant register cooperative society heard the matter, and thereafter, my lord, no copy was supplied to me. However, my lord, as copy was not supplied, so I filed an appeal.
Who is respondent to?
Respondent number 2, my lord,
Please the register.
assistant
The
registrar.
prayer is to dispose of the appeal.
Yes, my lord.
So we close the matter with a direct.
My lord,
Heard,
within a time frame, my lord.
Lordship, Lordship, I can look the section 36 for my
Aye.
36 for the copy. The limitation date is 30 days. Yes, Lordship,
No, no, there is an appeal file.
assistant register.
Huh?
36 for
He says some
Well,
appeal
that is
is filed before the registrar,
Yes, my
which is pending.
30 days.
30 days, 40 days is for the registrar to decide.
Register.
The question is whether an appeal is pending.
Appeal is pending as per the repetition. Panel may dispose of the written right next to, but within 30 days they will have to file the appeal. And the time period is next.
That for your registrar to decide.
Lordship.
36.
36 5, my lord.
Case 23, my appeal member.
Is question directed get the respondent, more particularly respondent number 2, seeking a direction of the statutory appeal by under the example 7. So, petition that claims to be the elected president of the Ilajuri Supply Committee Limited for a term of 5 years, which is it was to be completed in the month of March 2020. However, in a meeting convened by the Secretary of the Committee on 1/7/2024 and presided by the Vice President of the Committee, various allegations were brought against the petitioner, and no confident solution was brought. Subsequently, several directives were issued pursuant to the meeting held on 1/7/2020. So, petitioner may refile an appeal before the respondent. So, the appeal was referred on 11/9/2024. So, according to the petitioner, the appeal has not been disposed of by the respondent. The prayer the director, the respondent number disposed of the said appeal filed by the petitioner. So, then, Ms. M.P. Mora, the standing counsel for the that the appeal be pending by filed within the limitation period prescribed under section 26(5). Period as it may be. The limited prayer of the direction to respondent on the appeal stated to have been filed with the petitioner as per provision of law. If in the meantime, order was passed in the same appeal, or that the same appeal communicated to the petitioner. So, the exercise being completed in a period of 30 days from the date of receipt of certified copy of the order to be furnished by the petitioner.
Keep your blessing. Obliged.
So the matter is my lord, taking of the current account of the petitioner, my lord.
When was it
Well,
released?
Probably after 10th of October. Full date is not known.
Till
Still, only amount is disputed, my lord. I want to take your lordship to the
and why is it being done under whose instruction?
instruction, my lord. I have got copy, my lord.
Yes.
On the ground of complaint from the National Cyber Crime Portal. Crime Portal, my lord.
Some online fraud has committed, my lord, through transaction, my lord. That is the, my lord,
I am the
report that we have received from the, my lord, Cyber Police Patrol. My lord, the portal, your lordship will find, my lord, Annexure 5, page 19. The information, my lord, that has been forwarded to us, my lord, by the Financial Cyber Fraud Report Reporting and Management System.
What is this system? Whose system is it?
My lord, this is the system, my lord. It is reported, my lord, that, my lord, the police of Odisha, my lord,
Where?
Odisha police station, my lord.
Where is it stated?
My lord, it is stated, my lord, at the my lord, fraudulent transaction
Which
detail.
page? Which page?
My lord, page 19, Annexure 5. Page 19, Annexure 5, my lord. Down below, your lordship, at the middle, your lordship will find, my lord, fraudulent transaction detail. My lord, his account number, serial number 1 appears. This is the number, my lord, current account of the petitioner, my lord.
So when was it frozen?
My lord, it was in the month of, my lord, I'll take detailed instruction, my lord, in the month of, my lord, October, my lord, and since then, my lord, the investigation is on. That is what, my lord, we have been instructed, my lord, and till completion and inspection, my lord, we are directed to freeze the account, my lord.
So you're directed by whom and by what?
My lord, I'll take
That is
instruction.
what we want
Yes.
to heard.
May I pray one thing, my
Another
lord?
counsel for the
My lord.
Yes.
May I pray one thing, my lord? Disputed amount is in this transaction, my lord, mentioned only rupees 150, my lord.
Let him get the instruction.
My lord, that is the problem is this, my lord. Total disputed amount is 39,000 something, my lord. My account was blocked. That is today on balance was on 31st March 26 lakh, my lord. So may I pray the one thing, my lord? Business is blocked, my lord. So your lordship may direct the bank to keep 40,000 reserve. And
Let us understand on what basis it has been done.
my lord, that I
Who is
have mentioned in my lord.
Where?
On the basis of portal fraud, my lord. Cyber fraud.
Only
Cyber fraud. My client transactions is 8 layer, my lord. 8 layers means, my lord, first amount was drawn by the accused, my lord. Then 8 transactions. After 8 transactions, amount came to me, and disputed amount is only, my lord, 150.
Well, that is their conviction.
No, as per the statement, they supplied it to me.
I'll have to take instruction, my lord, as
you
to
take
what
it and come back on Friday.
May I pray one?
my lord, my lord, my lord,
Friday.
yes, Naharkatia,
Not Naharkati, Kharpetia, Lalpur branch.
Lalpur branch.
Get it in on Friday.
Friday night, can it
Well, I have already suffered fellow.
9.
Monday I'll take it.
9 heard. Mr. said will obtain instructions from the bank. Punjab National Bank. Which bank is it?
Punjab National Bank.
Punjab National Bank that and the procedure taking account of petition. With the instructions we place the vote on the next date is 9th.
Second, my lord, is next, next
Sorry.
Monday.
Sorry, second. Second is the
May I please, your lord. Lordship, we are the owner of a land lordship since my father's 1975 and 76 lordship. Now the deputy commissioner has cancelled a mutation after, and my name has also been mutated in the year 2013 and now 2023 lordship behind my back, and without jurisdiction they have cancelled my mutation lordship. Okay, impunity is 104 lordship.
You have a remedy under the provision
Lordship,
regulation.
in that case, 145 Assam Board of Revenue is live. But in this case, Lordship, the circle officer has cancelled my mutation on the order of the Deputy Commissioner, Lordship. Lordship, kindly come to 104, Lordship.
104.
104 page number. And there is a civil suit also pending. They could not get the injunction, and in solution, they have issued it.
Let him obtain instructions here.
Lordship.
Where is the reference in page 104?
104, as per B, Lordship, as per resolution adopted in, Lordship got it, meeting held at 11/12/2023
Yes.
in the office of the Deputy Commissioner. The Kamrup Metropolitan Resort, and in accordance with the letter number so and so dated so and so, in connection with dispute PS case number so and so, the fraudulent suspicious registered deed number 1976 and 7 relating to land number, land measuring so and so.
All right. Heard. Steps on respondent 4 and 5 within 1 week. Trustees with the respondents more particularly respondent number 23 complete their instructions and apprise the court of the next week. It's on 13
December.
Obliged. But till in the meantime, no self permission to be issued to any other party. Status quo as on today may be maintained in respect of that.
status quo till the next external case status regard that that be maintained by all parties
Obliged.
in the next week. Yes, Mr.
Lord, this is a petition challenging Miller the notice under section 74 of the GST Act. Lord, the facts are in a very narrow form. Lord, I was given a contract of a construction of the highway from Dibrugarh onward. Long before the GST Act came, it came, as your Lordship know, from 1/4. So it was given much earlier. So it took a long time because of some complication about land acquisition. Ultimately, it was completed by 2020. Now, we are concerned here with, we have, they prepared the bill, we endorse that they have paid, there is no problem with that call. But there was a clause in the contract which said that if the input component price goes up, the contractor can make a claim and then they will decide. So, pursuant to that clause, the petitioner made a claim and it took them quite a while, but ultimately the NH authorities decided in favor of the claim and intimated us that they have determined about 36 crores as what they call price adjustment. So we are really concerned with this in this petition. Then, when it was given, my lord, there was a slight confusion with regard to applicability of the Act on a contract executed much contract issued in favor of the petitioner early. So that was a hazy area. But so far as this present case is concerned, once without if your lordship kindly see page 99. After determining the amount, they are required to intimate the contractor, which they did by this. This is the earliest in point of time. And if your lordship sees, the amount here is mentioned as 36, 47, 13, 258. And the contractor is required also to give his consent or rejection, which is in the last column stated at page 99. My lord has seen that in the first bracket.
89.
99 minutes. I'm sorry, 99.
Yeah.
All the details of the petitioner, GST number, everything is given. This is sent to us and the amount is indicated and status, last column is status. This is accepted or rejected. So the petitioner accepted this and sent it back. Therefore, my lord, this is the document which indicates that the respondent authority, GST authority, plus petitioner both have come to know about the amount toward the claim, and it is reflected here. Now, my lord, once this happens, your lordship are aware of this, my lord, act, my lord, I see it because there is a clause in section 49(7). Your lordship sees that. Page 53 of that book, my lord. Section 49(7), page 53. All liabilities of a, sorry, yes, give me a bit. All liabilities of a taxable person under this Act shall be recorded and maintained in an electronic liability register in such manner as may be prescribed. So this is a prescription comes, Millard, in Rule 85 at page 234 of the book. Your lordship, I am giving, but it just gives the format. It doesn't, not very relevant, but except, Millard, that it is required to be given. I think it is 234F. F. There are two registers under this Act. One is called Electronic Liability Register, which is Rule 85, and Rule 86 is Electronic Credit Register. My lord has got it.
Yes.
Page 235, 4F, Rule 85. The electronic liability register specified under subsection 7 of section 49 shall be maintained in form so and so for each person liable to pay tax, interest, penalty, late fee, or any other amount on the common portal, and all amounts payable by him shall be debited to him. And then, my lord, the other register, the lordship sees in the same page, it is called electronic credit register, ledger, rule 86. So these are the two, documents statutorily required when this page 99 comes. So they will be required to record and maintain these details in these two documents. That's the position. This I am showing because ultimately, my lord, the whole question is now we are challenging that rule 24 notice. So this will go to show that both the authority plus the contractor are aware of the liability and it is recorded and made. Now, my lord, when that happens, my lord, there was, my lord, some correspondence and meeting because they started an investigation because this is an amount which has come into the record that we received about 36 crores and all that after deduction of the TTS. Therefore, my lord, our initial stand was that since this is adjustment of something which has already taken place under the Act, so it may not affect that. But subsequently, we also changed our view and told them that yes, it may partially be applicable. So it was at that stage, my lord, they issued this notice under section 74. Now, section 74, as your lordship know, my lord, just the other day, it is a few.
According to you, there was no suppression.
My lord, three things are required: suppression,
Willful mistake.
Misstatement, and fraud. That is the jurisdictional fact so far as 74 is concerned.
So according to you, these are all electronically maintained, it was available.
How can I suppress? How can I, my lord, uh, what is the fraud I can commit and what is, this is a known thing. Therefore, my lord, whatever it is maybe that we have not paid it fully. We have paid, but we have not paid fully. But there are other measures for that under the Act, for realizing it is non-payment by itself is neither suppression nor fraud nor.
Why not an appeal?
No, my lord. Why should I go to an appeal? This is a jurisdictional fact, as your lordship know. The condition precedent for initiation under section 74 is, my lord, that these three things must be present and he must apply his mind to that and be satisfied before he initiates. Now look at their own document at 136. And on the basis of that, we have filed IT return, we have filed annual GST return, and all that is shown. So there is no.
Where is the order path?
Yes, that is what I was about to say. This notice is at page 136.
132.
132. And kindly turn to 136. This is the impugned notice under section 74. Four point seven. 4.7, kindly turn to 146. 7.3, last paragraph. It has also been noticed, my lord has got it, at page 146.
146 is 7.2 and 7.3.
3. I'm talking, I'm reading out 7.3. It has also been noticed during scrutiny of records documents submitted by the noticee in course of investigation that the noticee has failed to self-assess and pay their GST liabilities correctly for the period from July 17 to March 2023, thereby suppressing GST liability amounting to so much, and that is, this is central government, and the state government is 2.18.
So where is the ground for invoking the jurisdiction in the show cause?
That is the ground, main ground, because they think
This is the show cause.
this is the so-called non-payment. Thereby, I am required to, they are satisfied that it is suppression or fraud or all that. That's the precondition. This is a jurisdictional fact. You have to be satisfied about that. So this, your lordships have also,
There is no order passed.
this is the so-called.
No. Is there any?
No, we have not submitted our so-called. We have come before your lordship. Because this is a condition precedent. If we are not, if he is not applying his mind at all, why should I be dragged to a longish process, below?
But then this
We
is
have paid about 30 lakhs towards this.
so
That is part
that's all
payment.
right. But you can raise these issues by filing your reply that there is no jurisdiction to invoke.
No, that is true, Miller. I can reply, and I can also come before lordship. That's your lordship's judgment.
Correct.
It started with Calcutta discount, Miller, in 1961, as your lordships know, and that is continuing. So, in fact, my learned friends have got some of the High Court judgments and also the
So
Supreme Court.
there is a circular in your favor. Is it a part of the pleading? No.
No, I am not aware. That's why I said that your lordship-
Your adversary counsel, if he is large-hearted, he can share it with you.
he is always there with us. So this point is even the other day we have got the order, another
Circular, you have the number?
So in this case, what happened, my name was not known, so I missed the
You get the instruction that there is a circular on this specific point.
yes, and the lordship section 128 recently amended. Probably petition will get benefit under that section.
So that's why I said to you, he is very fair. So your lordship may issue notice, let him also take the instructions and without
So first, let him find out if you are otherwise entitled to the benefit under the very recent amendment. The very recent amendment.
I have not seen that. I'll go through it.
So if you are entitled to the benefit, then perhaps you need not.
That's why I am saying, keep it pending.
Right.
And let him take instruction. And only it is 6th and 4th, this proceeding. So your lordship will say something that it should not proceed on 4th. Then your lordship, he can have his time and you can have it whenever your lordship.
Heard, sir. He has anything to submit from the respondents?
The respondent is concerned.
No, state is not.
You are not concerned?
No.
It's a federal.
It's a central. Yeah, a national highway.
Heard Mr. P.K. Goswami, learned senior counsel by Mr. Raj. Written is directed against the show cause issued to the petitioner. Dated.
One is 3.8, the other is 4.8.
132 is one.
That is, this is
page number
3.8. and the summary at page 126 is 4A.
So you have been issued two show cause.
Yes, yes. One is summary, and that is your lordship will get at page 126, and 132 is dated third of third August, 132.
No, this is a part of the same.
Same thing.
ERT1 is how it is related to ERT1 NOP.
That's right.
That is
So the
conflicting.
show cause is at 132.
Yes.
What is the date of the show cause?
This is 3824, and that summary is somehow 4824, which is at page.
No, where is the date indicated in the show cause?
Yes, Peter.
Page 149.
It is there.
Show cause dated
3824 at page 149.
3/8/2024.
Yes.
Issued by the Joint Director. GST. Intelligence, Guwahati Zonal Unit. As to why powers under section 74 within bracket 1 of the CGST Act 2017 should not be invoked against the petitioner in respect of amount raised the show cause notice at paragraph 8 thereof. So, counsel to the petitioner submit that for invocation of jurisdiction of the department under section 74 the CGST Act 2017, there must be prima facie evidence suggests that petitioner had resorted to willful suppression of a misstatement or
Misstatement.
what is the other one?
Misstatement and then fraud.
Fraud. And thereby depriving the revenue of tax due to be recovered from the petition. Relevant counsel to submit that the amounts paid by the petitioner are maintained in the registers prescribed by the provisions of the rules read with the Act, and these are clearly reflect the amount of tax paid. So he therefore submit then unless primarily there is some material below the jurisdictional authority to arrive at a conclusion that there was an attempt by the petitioner for willful suppression of a misstatement or fraud, and thereby attempting or depriving or depriving the revenue of the taxes required to be paid by the petitioner. The respondent authorities cannot continue to be written under section. So he is also referred to the circular issued by the Central Board of Income Direct Taxes and Customs to submit that the ministry, the competent authority has recently issued a circular on this issue and had clearly held that and had clearly instructed the revenue authority not to invoke section 74 unless there are instances of willful suppression of a statement or fraud. So mere failure to pay appropriate GST will not be considered a ground for invocation of Section 74. Further submit that the law is respected very clear. The circulars issued by the authority are binding on the departmental officers and they are duty bound following. So, perusal of the show cause notice does not reflect that that the initiation or invocation of jurisdiction under Section 74 of the GST Act against the petitioner was considered to be outside the purview of the so circular declared by competent authority. Therefore, that where the authority prescribed under the law has assumed jurisdiction on vested or notwithstanding any alternative remedy prescribed, the constitutional court will have jurisdiction to invoke its discretionary power. So, is referred the judgment of is referred to judgment of the apex court rendered in Calcutta Discovery and the subsequent law developed by therefore that the petition should not be relegated to participate in the proceeding, which was initiated by an officer contrary to the law laid out by the court, as well as by the Department of Circular, and thereby usurping the jurisdiction not vested in statute. We submit that appropriate order and the independence adequate that Mr. S.C.L. State here, settled here, and Mr. Gogoi is for
Respondent number 7, the PWD.
hearing for the performer as well. Mr. KL submits that like to pay and he tells that petitioner could be benefited by the recent amendment carried out the GST Act. Pursuant to the 108
128 capital.
Pursuant to the GST recommendation. GST Council recommendation.
Yes, sir.
Amendment you are
It has been amended.
He therefore brave to the court to complete the instruction. Mr. B. Gogoi appears for the performer. Paragraph the reading. Respondents complete their instructions and 5%. Invite further proceeding. Understood.
Person being
Pursuant to the show cause notification and the 17th. Tell the next date in the next date. Next date. Give us a date. 9th of December. 9th of respondent counsel will be served with sufficient extra copies of the recognition within 2 working days from today.
Okay.
Please report. One minute. Yes. Yes, any objection?
No objection. If your lordship can fix it after 10 days, your lordship. In the meantime, we will file it, reply your lordship.
It's a rate for some date with respondents to that the affidavit will be filed. Are you sure by tomorrow? Submit that the affidavit will be filed within the course of this week.
Lord.
MSFT for IPS for
Transport Department 1 and 4, my lord. We have already filed affidavit.
1 and 4, submit affidavit. Fine.
Sure.
There are Mr. That the matter be listed after 2 weeks.
Lord.
By which time the reply affidavit can also be filed with the affidavit filed and proposed to be filed by the report. Want a date? There is an interim order. 9? 9 December.
Lord.
Oblige.
Interim order till that date.
Lord.
Sure.
9.
Oblige.
Extend.
Oblige.
Yes, Doctor.
Yes.
Also, on the last date, I had made twofold submissions that I have paid a sum of 56 lakhs out of 58 lakhs, but still my bank account remains attached, and the order of attachment has not been served upon me. Lordship had granted time to the state respondent for instruction.
Any instructions by the state respondent? Finance and taxation. Who is there? Mr. Gogoi was here.
Yes, he was, sir. He was.
See, if you could have got hold of him, then we could have passed an order, but now you have to go and find him and inform all finance, taxation, etc. After some time. 656 also same.
Not attachment, same petitioner, but here I have all challenged the order which has been passed.
Same
without-
respondent council.
Same.
55, 56 after some. You what instruction?
Yes, was registered lordship FR was filed.
FR.
Who's already intimation to me? FR also I have to get the information.
You have to go before the competent court. Why no intimation was granted to you?
Well, the CM has not yet accepted. Or submitter has not yet accepted or not known. We'll inquire it.
Or 24/7.
But our grievance is here. Without the authority and an FIR from any quarter, the police of Patran Bazar went to our house along with the
This FIR which is filed is in response to an FIR filed by you.
Yes, yes.
Filed by you.
It has been direction. Initially, they did not register any case, but when the CR case was filed, Lanet CGM has directed to register a case. Then they have registered a case. Now I have come
This
to
is
the
against the respondent
Yes.
for forcefully taking away your dog.
Yes.
And there was a FIR filed against the petitioner also.
That we did not get, never. Itu number di sini.
So first thing is, if the FR is filed, you are asking for compensation. You are asking for, you have two prayers.
Yes, yes.
First is impartial investigation. The second is compensation. Now, if an FR is filed, whatever they have submitted is before you to file objection petition before the competent court to decide. Now, unless there is a finding that yes, there was a fall on the person or on the police who have not taken steps, there can be no ground to decide on the compensation issue.
Very true. Very true. Unless we could come to the
So
conclusion that
we
that
can
he
give
is
you
involved,
liberty to withdraw and come back later.
with the liberty to come again.
Heard learned counsel for the well as for the department. They submitted that by Mr. Rental from the government that in connection the police station case number Bolton was the PS case number 61 of 2024. Pursuant to investigation, final report has been submitted.
Give it a record.
We'll keep it here.
Look.
It's submitted.
Second page.
By the investigating officer. But where have you stated that FR has been filed?
Next, second page, Lordship. Stop, Lordship. Before the second
Finally
paragraph.
filed an FR in PS case number 22 ID. Bolton was the PSFR number 141 dated 24/7. Where a counsel for the petitioner submits that he has no information whether an FR has been filed. And the government advocate submits that although FR filed, there is no instruction whether any same has been accepted by the competent court. Where the prayer made in the writ petition are both, namely seeking a direction to the respondent authority cause proper inquiry and proper investigation in respect of the FIR filed by the petitioner and registered as Bolton Buzzer PS case number 61 of 2024 under section 208 number 15. And for adequate compensation to the petitioner for causing death of our pet dog by the respondent. In view of the submissions made by the government and the instruction made before the court, since an FR has been filed and there is no instruction as to whether the same has been accepted by the competent court, it is open to the petitioner to approach the court of competent criminal jurisdiction before which the FR has been filed and take necessary steps in that regard. So, insofar as the compensation, prayer for compensation is concerned, unless there is a finding that there was unless there is a finding by during finding evidence from the investigation conducted that any or all of the respondents were responsible for willfully causing death at top of the petition. The question of compensation cannot be determined as of date. Accordingly, petitioner is granted liberty for the competent court of criminal jurisdiction. However, at the request of counsel for the petition, at this stage, the writ petition stands dismissed on withdrawal, however, with liberty. A copy of the instructions placed to the court made by the London government is kept on record.
Annexure 16, page 79, my lord. Include notice, my lord. My lord, notice of demand, please take notice. Certificate number so and so has been forwarded to page 79, my lord. Annexure 16.
79.
A notice of demand was issued to the petitioner, my lord, demanding rupees 1 crore 12 lakh something, my lord.
Who's for the respondent?
My lord, what has happened in this case? Earlier, similar kind of notice was issued earlier. Okay,
Who's for the provident fund?
Yes, my lord. Page
Yes,
6.
Mr. Counsel, who's for the provident fund? You are appearing for provident fund. Yes.
My lord, prior to that, similar notice was issued. My lord will find at page 60, my lord.
So you approached the authorities.
Yes, my lord. There was a, my lord, page 60, my lord. I have already approached earlier. Page 60, lordship may come to our.
Heard, Mr.
My lord, thereafter, a repetition was
Learned
preferred in
counsel
this
for the
connection.
petitioner, Mr. A. Bora for provident fund.
He will anyway get more than 60 days.
My lord, what
to
is
redeem,
happened?
my lord. Whatever his grievance is, it is based on his certificate that we prepare the.
No, my lord.
form.
Earlier there was a high court. We have done high court, my lord. Lordship may kindly
Those
come
were
to
the
page
earlier
60, my lord.
Not regarding the
Page
PFD.
60, page 60, my lord. In connection of this notice, we preferred a writ petition before this honorable court, my lord. My lord directed, lordship may kindly see page 63. Now different notice, page 64, my lord, relevant provision, according to their submission only, my lord. Learned counsel so and so urges that section 15D and E
So
of
what
the
happened to the earlier notice?
Yeah, my lord, they did not respond to it. As per this notice, I have applied, filed an application. Lordship may kindly come to page 70, my lord. I have filed an application as directed by this honorable court, my lord, to furnish me all the documents on the basis of which they are claiming, my lord. And they have come up with this reply, my lord, 15-7, my lord. And they have given just 4 days I have filed this application. Thereafter, my lord, I have given a reply to them. Lordship will come at page 73, saying that whatever you are demanding is not tenable in the eyes of law. And to this, they did not give any reply, my lord. And thereafter, my lord, what has happened? Again, my lord, before the High Court, Lordship may kindly see 68, page 68. Page 68, again the matter came up 31/7/24, and paragraph 5, Lordship will find, take notice into account the state communication which has been marked as so and so, as well as submission of so and so. Counsel of the respondent impute notice is deemed to have been withdrawn. They have withdrawn the earlier notice, and again they have subsequently issued this notice, madam, with a different amount, madam. My submission is that whatever legitimate amount I am ready to pay, madam. But this is not the way.
What happened? What happened? What happened again?
Lordship, they came, there's a letter. Lordship, may kindly take a look at page 70. They came back and said, we've given amounts. So what we did is this. Lordship, second paragraph. It may be kindly noted that the earlier recovery dues were wrongly took as 85 for a period of so and so, which is now removed. Then there are all these corrections of figures. Then Lordship, the last paragraph. With regard to your statement made that a payment of 22 lakhs towards discharge of liabilities of a receiver, Messrs. Jnex Tea Company Private Limited, it is stated that the amount of 22 lakhs was paid against other statutory dues and not against PF dues. Please take note of the fact that the receiver was appointed to run estate only for the reason that you had failed to pay, even pay the monthly wages, and there was an apprehension of breach of law and order situation. The recovery certificate due is only with respect to Provident Fund and other statutory dues.
No, there was an order by the court.
Yes, Your Lordship.
They were asked to appear.
Yes, Your Lordship.
Then they appeared.
After that, this is what happened. They reconciled.
No, you, there is an order at page 69, part of the order,
Yes, Your Lordship. Your Lordship's order.
the coordinate bench order, 69.
Yes, Your Lordship.
So this order was
This is complied with.
I know, but
For the sake of compliance, they
And
comply,
then
but
there's a
they
notice
have
of demand,
legally
fresh.
again putting me the
There's a
demand.
notice of demand which they're impugning now.
what is this Communication Acts? Para 4 in page 69. What is these acts communication? On the basis of which writ petition was closed.
I was not even served a copy. And Lordship categorically, prior to order, my earlier order, you furnished him the
No,
copy.
Lordship, this is instructions. No, this is instructions from the PF that we will not press the earlier notice of demand, and we invite them to come to the authorized officer. Lordship, under the Act, they can always go to the authorized officer.
They claim they have been there, but
Yes,
you have
Your
not
Lordship.
furnished the required.
Lordship, page 65, Lordship's order, page 65, my lord.
Lordship.
Last paragraph, the petitioner is permitted to approach the authorized officer for
It is their
clarification
submission that they had approached pursuant to that, but it's
We have replied with
or
page
rectification
70, which I read out.
and furnish all the relevant documents.
May I explain something, Lordship?
That was not compliant.
We are only concerned with PF dues. Under the Act, if there's a default of PF dues for a period of time, it empowers us to do ABCD.
All right, heard, Mr.
Lordship, my only prayer is you may not stay it. The 60 days more.
Why so?
As
No, not at all. I am agree.
May I argue on that then?
No,
he goes up to the
I am ready to pay the exact correct amount.
3. 1 to 3.
Yes, Your Lordship, all the respondents.
Because the respect of where is the note? Where is the notice?
Notice, Lordship will find
It's page 9.
page 79.
8?
79, my lord.
And Lordship, can you take a look at page 80?
79. Notice of demand dated
Just a mere calculation table won't do.
12 11
11,
2024, whereby an amount of 8 1 comma 12 comma 29 comma 020.57 is was demanded as an amount towards provident fund payable by the petitioner, the responsible authority. So the breakup of the amount that goes the same communication. So, the council for the petition has referred to an order again where the notice of similar nature was earlier issued. So this court by order dated 28 2024 by that suspended the enforcement of the same. Subsequently, on 31/7/2024, on the basis of instructions furnished by the Provident Fund Authority, on the ground that the earlier notice that terms of the communication placed before the court, the earlier review was considered to have been deemed to be withdrawn. And it comes to response to the communication. Submit that communication dated 7.
My reply is at page 70.
The petitioner is to pay the money and clarifying that an amount of 22 lakhs stated to have been paid by the petitioner was paid against other statutory dues and not against Provident Fund dues. The under such circumstances, the petitioner has to this court demand stating that there are disputed amounts have been included. According to him, he has paid some amount.
Lordship, after reconciling all of that is we issued the notice of
Regarding
demand.
22
They
lakhs,
can't
I
be
have
coming
also,
back and saying the
regarding
amount
22
1
lakhs,
point.
I have given my reply, my lord.
One by one, I'm asking the counsel for the respondent. You'll get your opportunity. Yes.
Lordship, page 80, 1.12 is after taking into consideration the errors on the earlier demand and the amounts paid, but excluding 22 lakhs. The 22 lakhs is the only thing he said we will not because it's not PL.
The respondent counsel submits that demand notice issued after proper record and having found the amount due to be paid payable by the petitioner. Stops the state submission is disputed by the petitioner draft that already discharged by the petitioner has not been taken into account or when the benefit there. Further submission regarding the respondent is that the notice is issued on 12/11.
Yes.
And it's granted 60 days. Where is it provided?
Lordship, in the schedule to the income tax rule.
Huh?
Basically, Lordship, 15 days after notice of demand, and then after sale notice, 30 days, and even after sale, 30 days.
He's been asked to.
And there is a
deposit
provision of
the paid amount
rectification also,
within
my
15
lord.
days from the date of the notice. And therefore, it is
Earlier order-
permitted. You want to obtain your instructions here?
Yes, your lord.
Instruction. And no interim order for that. Counsel for the petitioner, however, submits that the demand is unauthorized and therefore admit that order be granted. So,
Lordship may give a short date. We file it within a week. Let the process go on. Otherwise, it's the dues are from your lordship 2000, and he keeps coming back to court
Yes,
for
there is a process of
as
my
the
lord,
26th is for
sabotage,
rectification
sabotaging
of-
my garden, my lord.
returnable
I'm vested in this.
weeks since the respondents are represented by the council the way that meanwhile in the event the department proceeds the matter on which the notice of demand dated no final order passed without leave of the court. With the matter being listed on 16th of December.
Oblige your lordship.
69.
I will be allowed to approve.
Mr.
Devati to approve the
Counsel,
appropriate.
Mr. Mazumdar, like, accordingly, it is, it, the date of appears for correspondent big four, 2 and 3. MSPR from correspondent. Waka 4, anybody?
No, lord. But liberty may be given to appropriate forum.
Why liberty is necessary? Appropriate forum is who?
I have filed this document during this period
The
sometime.
petition is permitted to be withdrawn in prayer of the petition council seeking liberty to appropriate forum prescribed under the law. Third, prayer allowed.
Allowed. There is an eviction operation. That matter 16 some matter. And
16.
WBC number case 3131.
Hmm?
Case 1.
Which? From where?
Page 130.
From Sonapur.
Kosotoli.
It's a different area.
Sonapur area.
The other one is Jagi Road.
No. All are Sonapur and Kosotoli.
Third done a couple of party. When is the matter fixed?
1611.
Return of fixed. The actions are brief. Challenge the fiction.
They are already evicted.
They are evicted.
Yes.
Then what are they claiming?
We are claiming that we have been evicted without serving any notice. We suffer heavy losses, my lord. That is why we filed this novel.
Trying to challenge the eviction already carried out. By this one. It's submitted that it suffered losses. They have not been adequately compensated, nor any alternative space has been allotted for their resettlement. Or they have their books directly to restore them.
Yes, page 135 is the operation. Page 135, the director to file affidavit.
After return of date, right? Respondent need to advise it communicate. Right. Yes. No one for the petitioner.
Lordship, there is no one for the petition. Lordship, it's a matter of true lordship. I may lordship may take an appropriate call in presence of my senior.
There is one for the petitioner. For
he did ask for lordship one, lordship response number one.
I appear for two, my lord.
Actually, Mr. Ardube was appearing for S1 number 1, 2, 3, 4. But later, lordship for S1 number 2, Mr. Peter senior.
Whoever is there,
yes,
so
lord.
report in the record. See, matter was Mitra was
yes, lordship. But in April, lordship, they have withdrawn perhaps lordship. They have withdrawn from the they have withdrawn the Bakla.
In
not appeal.
obliged.
If I'm appearing on behalf of Mr. B. Gogoi, lordship, he is on legs, lordship. I'm appearing for the authorities in the PWD.
Complied, not complied.
Lordship, lordship, here we were directed to place a status report regarding the valuation of the land. Lordship. The report is with me. If lordship would like to.
Not the land.
Bring it on record. Bring it
Not
on
with
record.
regard to the land loss. It is actually the demolition of the building. So they have to assess the loss that has been suffered by the petition.
Yes, lordship. That assessment is with us, lordship. Lordship,
Bring it on record.
lordship.
In the form of affidavit.
Yes, sir. Sir, we can do that.
Mr. S.P. Chaudhary for the petitioner, Mr. A. Chaliha appears for the
What is
PWD.
Yes, lordship.
Department, Mr. M. Bhagavati for
Correspondent number 1.
respondent number 1. And
My lord, PK Roy for respondent number
DK Roy for respondent 3. Who's for 2? Mr. Chalia. Appears for respondent number 2. He submitted that an assessment. What is that assessment?
Yes, Lord.
Has been made by the respondent authority in respect of the damages stated to have been suffered. What
Yes, the
what does it
demolition was
say?
done, Lord.
What does it say?
The physical verification report and valuation.
What is the conclusion?
Lordship, where there's an amount, Lordship, that amount of valuation that the loss has been
So
the value.
the losses suffered has been quantified. Losses suffered by the petitioner has been quantified, and according petitioner and respondent, counsel for respondent to raise before the court, bring the same by way of an affidavit before the court. According to the matter we discussed after 2 weeks, good evening, Mr. Chalia had filed an
Can a date be fixed?
quantification of the court. 16, 17, 13.
13.
This, my lordship will place this matter for admission hearing for disposal because I am suffering. My lord, and certain records will be necessary for IOC to file. The matter is what records I am telling you, lordship. My lord, I am the admittedly owner of a land. I leased it to one of my friends. He applied, got indent, my lord, and I allowed him for 10 years lease. That expired. He died. Then we don't know. It's still being run.
Who is for the IOC?
IOC, the friendly council. We don't know, my lord, how it is being run after the death of my friend. This is my land. Admittedly, I am the owner. So let them produce the record to the present state.
That's what?
That will come. That will come.
I'm not getting clear.
Nothing, I am not getting, I am owner, my lord. I want to build a house of my own. Somebody is running now, we don't know who is running. We have given repeated annexes after the death, demise of my friend.
But why the report?
Yes, my lord. Because my lord, 300A will come and they are a state within the meaning of Article 12.
Well, there is state.
It is a state action.
But to verify your land,
Your lordship,
require some evidence.
I'll fetch certain decisions. My lord, they are a state within Article 12 and you cannot deprive property without in accordance with law. 300A will come. Constitution article.
Data, appearing for example, 1, 2, and 2.
Let us produce the
And I'm appearing for respondent number 7, newly impeached.
And Dina. For number 5. Right.
Nita.
The matter for admission in January.
My lord, no, but December, my lord, maybe
December.
in second week of December.
Very difficult for admission hearing. Let us have it in January.
January, my lord, then second week, my lord. 7th of January, Tuesday.
7th of January.
And my lord, lordship may indicate the records
By
about
the respondents will keep the relevant records necessary, relevant connected records of the case for perusal of the court if so required.
with regard to my lord, current status of the petrol.
Whatever record is there.
Lordship, problem.
Regarding response number 6, I have been instructed to appear. We are going to file appeal number 6.
Service may be incomplete.
The learned counsel has entered appearance on behalf of respondent 6. Accordingly, all respondents are served. Mr. S.K. Deori appears for petitioner. Mr. Tanukar for
1, 2, 3, and 4, my lord.
One. Let the matter be listed for admission. After 3 weeks, respondents may file their counter affidavit.
Look, there is interim order.
Interim order passed earlier will continue.
Right.
2 weeks. All right, let the matter be listed on 6th of January. Interim order to continue till the 6 weeks.
Right.
Yeah. Yes.
May I please, Your Lordship? It's a contempt petition, Your Lordship. In this case, Your Lordship, as per office note dated 21st 11/24, Your Lordship, service report has been added in respect of respondent number 2, Your Lordship. Although Your Lordship, respondent number 1 filed wakalat
Service report awaited on respondent 2.
2, Your Lordship.
You want to take fresh steps for Dusty?
Lordship, we have taken a step on 1st October, Your Lordship. Once else maybe, otherwise we will take.
Petitioner is permitted to take fresh. When did you take it? 1st October.
1st October.
All right, let the matter be listed in the month of January.
December. First week of, last
Third-
week of December.
Second week of January. As the service report on respondent 2 is awaited.
So,
As per office note. Yes.
Well, I am appearing for the respondent number 1, the sole respondent. Well, the Honorable Court directed the Deputy Commissioner or the ADC to pass an order, and that application has been considered. The order has been passed on 2/9/2020.
He is not aware.
No, he was present, my lord. In
You are
fact,
not aware.
yes, Lordship, petitioner was called and thereafter he has not what decision has been taken by the.
well, on 2/9/24 he appeared. The Hajira is there, and 2/9/24
But
order.
have you served a copy of the order?
Well, I'll give him a copy.
You have served him a
I'll give him.
heard learned counsel for the party in terms of the directions contained in the order dated 24/11/2023 passed in WPC number
209/2020.
09 of 2021. The directions of the court has been carried out and the respondent authority has conducted the hearing and has passed the relevant order dated 2/9/2024. So, learned counsel for the appearing for the respondent served a copy of the order to the petitioner and said copy also to the court. In view of the order passed.
The application has been rejected.
Huh?
Their application has been rejected.
In view of the order passed.
Lordship, let them file affidavit. We will file report.
View of the order passed on 9/2024 and a copy of which is placed before the court. Contemplation stands closed. Notices should are withdrawn.
So, okay.
We have recorded you served a copy.
Yes, no.
Ah.
And well, that order may continue.
Yes, on record.
Lot.
Copy of the order passed is kept on record.
Lordship, the matter I is instructed. The I was filed for the withdrawal of the petition, petition number 36, which was already withdrawn.
I, in view of the order passed 25/10/2024, that the petitioner has reached friendly arbitration further and the petition was dismissed. The IA number 3357 stands dismissed.
Highly obliged.
Okay. Yes.
Yeah, please, Lord. The I has been filed for impeachment of Union of India as a necessary party or something.
Who?
Union of India, your lord.
Okay. Any objection?
No, Lord.
Have you served a copy on the union?
Yes.
You're not here. Heard General Counsel for the party. This I has been filed seeking implement of Union of India as party respondent in WPC 3383 of 2024. Stop.
7748.
Huh?
WPC 7748.
Oh, sorry. 7748 of
2018.
2018. General Counsel for the party submit that on 1/10/2024 it was submitted before the court that due to inadvertent mistake, Union of India, represented by the Secretary to the Government of India, Ministry of Commerce and Industry, the Department of Industrial Policy and Promotion, and the Under Secretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy and Promotion are were not carried as party respondent. Accordingly, this IA has been filed. Seeking implement of the same. According Mr. Polita appears for the respondent industry department. He does not object rarely according considering the requirement that the IA counsel applicant counsel is present before the court. With IA stands allowed. Union of India by Secretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, Udyog Bhavan, New Delhi, and the Under Secretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy, Udyog Bhavan, New Delhi, are areas responded number 5 and 6 respect. I accordingly stands disposed of. The information you write in view of the order passed today, IA number 3383. So and so, I read as respondents number 5 and 6 to the writ petition. Petitioner will file amended post title before the registry within the period of 2 weeks from today.
Apply.
In this case, I'm appearing for respondent number 5 for the chairperson of Tekes Valley Municipal Court. Kindly 2 weeks time may be granted to us for filing our question. It is almost ready, Lord.
Your name?
A. Bora.
A. Bora appears for
Respondent 5.
respondent number 5. According to service of respondent 5, completed based after respondents may file their counter affidavit in the
All right, sir.
Your time.
Here I'm appearing on behalf of P. Hazarika on instruction. I will kindly peruse the previous order 11-9. 11-9-2023.
In this case, sorted, we have received an instruction dated 23 November 2024. The file is being processed for obtaining approval from Chief Secretary. So after approval, the funds will be released. What you may peruse my
Last occasion, it will take 10 weeks.
How long is it going to take?
My lordship may post this matter after 3 weeks.
Counsel appearing for the respondent Revenue Department. Submit that the concerned file is before the Chief Secretary.
Secretary Lordship. For approval, Lordship.
And approve it, and accordingly raise for further 3 weeks.
Lordship
time.
will pay the fine.
Copy of the by the council is before the court. Accordingly, matter be listed after 3 weeks.
Date may
8th of January.
8th of Can we keep the month of December?
Uh,
Maybe on 19th or 20th of December. But take it back.
8 of January.
Keep the
Not a in this matter, we have to find upon next week.
None appears for the petition. Mr. Nayak appears for the respondent. You want to file?
234.
Appears for respondent 34. You want to file?
One additional.
Seeks liberty to file one additional. Accordingly, matter be listed after 4 weeks. Enabling respondents to obtain complete instructions and file it. None appears.
Lord, I have received the instruction, my lord. This to be covered by, my lord, judgment of this court only. The claim is more than, my lord, 20%. Instruction.
What is your submission? Why do I am not interested in your
No,
instruction?
instruction is, my lord, the claim amount raised by the contractor is more than 20% of the contract value, and therefore, my lord, in terms of the contract agreement, the claim is not referable to arbitration.
This honorable court has already appointed arbiter where similar issue has raised.
And my lord, I am relying on the
Right,
judgment.
the matter be listed on 28th of November for admission here.
My lord.
Yes, please, Your
Yes.
Sir,
Yes.
may kindly pass over the matter for time being. My senior is on that.
let a matter be listed for hearing, Your Lord. Actually, I have there is a this matter actually pertains to this one issuance of a tender in a private property belonging to us. We are the original fattadar, and it is a honorable in the light of the honorable the division bench order. This honorable court single bench.
All right. Let the matter be listed for admission hearing on 9th of January
Obliged.
2025.
Yes, an interim order.
Interim order passed earlier will continue with the next sittings.
Obliged.
Yes. Matter be passed. Same order. Passed. Same order. Forty-three. Yes.
May it please your lordship. The lordship will kindly peruse the order dated 25/10/2024, wherein the deputy commissioner as well as the additional deputy commissioner was directed to produce the records as to why property has not been attached to your lordship. There was a Bakija proceeding going against the private respondent.
Yes, respondent, any
Sir,
instructions?
communication has been given, but we are yet to receive the present status of the Bakizai. So at least can it be
Heard
listed
Mr.
next
R.
week? So
Sinha for the petitioner, Mr. H. Sharma, S. Borwa for the respondent. S. Borwa, government advocate. Additional senior.
No,
You are additional
junior government.
junior government advocate appearing for the State Department. 6 further time. of the instruction. This matter in third week of January.
No, your lordship, the issue is within a very narrow compass. That why, in spite of there being a categorical admission,
We first will give us a date.
can it be on your lordship 6th of December, your lordship?
No.
The reason is very obvious, your lordship. These persons will sell the property and will move out, your lordship. This Bakija proceeding has been pending since more than 1 year, your lordship. And in spite of failure on the part of the private respondent to pay the amount, the ADC is intentionally not attaching the property. And this doctor, he has to come down from Manipur every time for this proceeding.
What is your prayer here?
My prayer is that they are not the statutory authorities. They are not proceeding as per the act.
How are you affected? Why are you affected?
I am affected because the order has been passed in my favor. The RERA has directed the deputy commissioner that you please attach the property, initiated Bakija proceeding, and give them the money. Now the deputy commissioner has directed the ADC, Bakija officer, that you please proceed. In spite of that, this ADC is not proceeding, your lordship.
All right, 11 December. 11th of December.
Deeply apologize.
31. Yes, 31.
I am the petitioner.
Item 31.
31.
Oh, that's the order.
Huh.
After respondent. Because for a PNR is approved.
Yes.
For a respondent number 7, we have taken a right side.
Yes, any instructions here?
Let's waiting for instruction. Waiting for instruction.
Heard the counsel for the petitioner,
Yes, sir.
order, planning council, PNRD.
PNRD.
Takes further time to complete the list after 2 weeks.
But there is the interim order.
Interim order will continue, then let it come in January, 20 January. Interim order will continue till the next date.
Okay.
None appears to pass.
Forty-six.
46.
Yes.
Yes, what do you have to submit? What do you submit?
Lordship, I have prepared for respondent number 1 and 2, Lord. And we have filed already affidavit.
Let the petitioner come,
Petitioner
he's not
request.
here. He's passing it over for the day. He come in the course of the week or next week.
Similar item 41. PRC value.
Huh?
Safari.
Huh?
Equals to PRC. Student is Safari. Petitioner is a student.
Wait. Let us deal with 47. Item 47. None appears. Yes, it is 41. Yes.
The petitioner applied for her PRC.
Oh.
Her PRC has not been approved only because in the voter list of 2005 of her father, my lord, in her grandfather.
Instructions?
Yes, that instruction, we are placing it by way of an affidavit because ultimately the grandfather's name seems to be different in two different documents that they have submitted. So for which we have been asked to file an affidavit. So we are filing within the course of the day.
All right, then let it come on Friday. Matter be listed on Friday as it is submitted by the learned counsel to the respondent that the state will file its affidavit during the course of the day. Mr. Cody.
Problem.
Yes. Time. 49 time. Yes.
Here the bank account of the petitioner that has been of the cyber of at page 33. That is the communication by which the account of the petitioner has been seized. On making an inquiry, the bank they have stated that because of 4 transactions.
Because of
4 transactions, the account has been freezed. Those transactions took place on 8th of March and 10th of March.
who's for the respondent?
SBI. And the reference number 3 and 4, my lord, they have sent their instructions, my lord, to the
Right, let the matter be listed again on Wednesday. Showing the name of the counsel appearing for the respondent, including the SBI.
SBI.
Counsel appearing for the SBI. Mr. P.K. Munir appears for the petition. List on Wednesday. Coming to. Yes, what is the status here?
Well, let us suppose that petitioner is on interim bail. After the director, we appear before the largest court below my law, and we are regularly appearing my law trial. My law.
What is the stage of the trial?
The case is pending for supply of copy. Petitioner is
When
showing
was the charge sheet filed? When
petition-
was it filed?
Lordship, as per the up-to-date status report, 12/6/24, part charge sheet filed and the part charge sheet petitioner is showing absconder. And Lordship, the
final charge sheet has been 4/3/24.
4/3/24 final charge sheet, sir.
And still it is in the stage of copy.
Perhaps some it may not be appear. So all the acquisition.
Let a report be called for from the. Let the registry call for report. Call for from the competent court, which is the court additional CJM.
Additional CGM Borpeta my law.
CJM Porpeta. In connection with
In connection with my law, PRC case number 1420 public 2020.
1420, PRC case number 1420/2023.
Yes, my
Let the records be placed before the court in the month of January. 8th of January.
Can it be on my lord?
22nd.
Yes, my lord.
22nd January. Interim bail granted earlier will continue. List recording.
Okay.
Yes.
53.
Who's for the petition? Unappeared. Pass over.
Your service report.
Huh?
This is complete, sir.
Service is complete. Is the
October.
POXO matter.
Oh. Legal aid has to be applied. Office net 6/20.
Office note dated 6/8/2024. That steps taken on respondent number 2 to the APP's office.
Services. Service report.
There is no indication that it is complete.
They have taken. Then I have to take instruction for service report.
Office to verify.
Yes.
Office to verify whether service on respondent has directed was undertaken and whether it same is complete. Placed after 2 weeks. Yes, what happened? Timing.
Speaking of bank account, the instruction that I received, my lord, they say that my lord, there is a my lord, fraudulent withdrawal of my lord, refund of that to the
Will-
various accounts of the petitioner as well as some other person.
We'll hear it on Wednesday.
So they are seeking some further time, my lord. Here about 17% are involved, my lord. Various bank account has been freezed, my lord.
No, but he has to survive somehow.
No, that's why I'm saying, my lord, let it be on Monday, my lord. At least by that time, I will place the entire instruction. Only
Yes.
there, but only 7 days they are playing. Let it be on Monday, my lord. Both I think.
Mr. T. Saraf, the council appears to the partner, Mr. T. Goyal, and the state DSP subject. The matter be listed on 2nd of December, by which date it will complete all its instructions.
My lord, complete.
List recording on 7th.
I won't.
Both the color till the next day. Highly object.
Yes.
My lord, in this matter, my lord, similar issue is, my lord, coming up tomorrow, my lord, where the arbitration notice has been sent not by the party, my lord, but by the a law firm, my lord, or rather, my lord, by the council, my lord. That is, yes, my lord.
Already settled matter has been settled by the Supreme Court.
No,
My lord,
no,
I
no,
have
not on that.
My lord, may I submit, my lord?
Now he's every day.
My lord, page 250 is the notice, arbitration notice. My lord, I have, my lord, give me 2 minutes, my lord, to print out
My lord, this issue, my lord, this writ petition, this section 11 applications can be disposed of, I believe, by appointing a sole arbitrator. My lord, I believe the counsel appearing for the railway will be ad random with me because after the coming of the larger bench decision of the Supreme Court, my lord, in the central organization for railway electrifications, my learned friend will be there to hand over a copy of the judgment, my lord.
It's reported, we have a copy.
Yes, sir. My lord, may I take your lordship to the relevant petition, my lord?
Yes, what are you submitting? 1 minute, Mr. Counsel for the Railways.
My lord. My lord, my submission is that, my lord, in terms of the definition
So
party.
you are basically objecting to the fact their submission that it is covered by the judgment, not covered by the judgment.
No, that is covered, my lord. No, that is not disputed.
Then what is disputed?
The disputed is, my lord, the fact that the notice of arbitration has, as per the law, my lord, under section 21, it should be sent by the parties to the contract agreement. It cannot be sent by
Where
the
is that authority that you're?
my lord, authority I have mailed, my lord. It is, my lord.
When is the other?
2012.
When is the other matter fixed?
My lord, tomorrow, my lord. Other matter tomorrow. To fix. Hmm? 12.
All right, then we have it tomorrow.
My lord.
My learned friend will be citing the judge authority, my lord, which on which.
That's what he proposes to do.
Yes. Oh dear.
We'll take it up tomorrow. He submits there's another similar matter on this issue itself.
My
Which is
lord.
fixed tomorrow.
My lord.
At the request or tomorrow or day after. Tomorrow is Tuesday.
Tuesday.
Let it be tomorrow.
Tomorrow.
But
Yes,
no, Mr.
Partha Banerjee, my lord.
Mr.
T. Banerjee.
Partha Banerjee, counsel for the petitioner within bracket of the DC, assisted by Mr. S. Deka and Mr. A. Gupta appearing for the Mr. Gupta prays for a day's time, rely on certain judgment in support of his contention that as per the provisions of the Arbitration and Conciliation Act of 1996, the notice is required to be issued by the party themselves. Whereas in this case, it was issued by the solicitor.
Solicitor.
Let the matter be listed tomorrow.
Okay.
Mr. Gupta will place necessary authorities in support of its objections raised. List according. 63-64, sorry, 62-34.
Grateful.
See, there is no progress in the trial as such. So we'd like to call for a report from the district judge, trial judge, as to why it has not progressed.
The still that lordship on
So,
the lordship the
therefore,
22nd date, but not witness is examined.
Therefore, we propose to enlarge you on interim bail.
Lord.
And meanwhile call for the reports. You will furnish bail bond of rupees 30,000 with 2 local securities of like amount to the satisfaction of the
Special Judge Kamrup met.
Special Judge Kamrup.
Met.
And this interim bail will continue till 27th of, sorry, till 18th of December. See, 37 hurdle is there.
Yes.
For the court to be satisfied, some evidence has to be there.
Yes, sir.
But no evidence is there because no witnesses are there.
Yes, sir.
So for now the court consider your application for bail and releasing you without there being any satisfaction on material that the hurdle on 37 will not be a part.
I think, my lord, to be honest, my lord, then Article 21 of the Constitution of India, my lord. That's why, my lord, I have given one judgment, my lord, where it has been discussed, my lord.
No, so therefore we propose to enlarge even interim bail for the time being. And call for the report as to why the trial has not progressed in spite of the charge sheet having been filed almost 2 years ago. So, third learned counsel for the party, this bail application has been filed by the petition in connection with such and such case. Petitioner was taken into custody on so and so date. And thereafter, charge sheet was filed on
Charge sheet filed on 5/8/20.
5/8/2020. So, report scan copy of the records called for from the trial court reveals that not a single witness has been examined till date. The counsel for the petitioner submits that the law as on date is that in the event there is no progress in the trial because of long detention, because of elongated custody of the accused, he is entitled to be granted bail. So, whereas it's having hard learning, not matter where the petitioner is taken to custody and investigation has not been completed. As noticed in the charge sheet, pursuant to investigation was filed on so and so date. However, the scan copy of the case report for the trial court revealed that witnesses have not been examined. So, let the trial court furnish a report to this court as to why, in spite of the charge sheet having been filed on so and so date, and the trial has not progressed and not a single witness has been examined. So, meanwhile, considering the period the petitioner has been in custody, and also considering the fact that in spite of the charge sheet having been filed on so and so date, no, the trial has not progressed because of non-examination of the witnesses. This court is inclined to grant interim bail to the petitioner. So, petitioner be enlarged on bail subject to furnishing a bail bond of 30,000 to the satisfaction of the what is that? Special judge, Kamrup.
Additional Session Judge number 1, Kamrup Metro.
Additional session judge, number 1, Kamrup. He's also the special judge.
Yes.
NDPS.
Yes.
Special judge NDPS. With 2 local sureties of like amount. So, the matter be listed again on 18th of December. Interim bail will continue. Extension of the interim bail will be again considered on the next date fixed.
MTP.
List according. The report in the meantime be called for from the trial judge by the registry report.
I'm obliged.
Let us have it on a hearing day.
Lordship,
What is
although
this?
it's a covered judgment, Lordship, by the Honorable Division Bench of this court, it here what happened, my eligibility certificate under the industrial policy was rejected based on Rule 57A, which was inserted by way of notification in the Assam Value Tax Act. This Rule 57A has been held ultra vires by the Honorable Division Bench of this Honorable Court. And in that view, my submission would be that the impugned communication has to be rejected and the matter has to be remanded back to the Industries Department for consideration of my eligibility certificate.
What do you submit?
Lordship, here I have misplaced the file. Lordship, just I borrowed from my friend a copy. Lordship, may take it up next week, Lordship.
Thursday?
Next week.
Next week. Let the matter be listed again on 3rd.
Third, can it be on 4th, Lordship?
Not 4th, 5th. 5th of December, on which date the at the request of the Standing Council, Finance and Taxation, as is submitted here, as he seeks to complete certain instructions from his client, from the department. Okay. Dr. Ekudi does not object. Fair me. Mr. Mudita appears to me, that's
Yes, Lord.